Good afternoon, everybody, and I welcome you all back again for this IUCEC webinar, Intellectual Property Rights. Okay. In today's presentation, I will give a general introduction to IPR. Okay, and why do we need it? What are its provisions, and what's its use and in the context of engineering education? So there is a single purpose for this presentation to provide a general awareness and introduction of IPR. That means what is this IPR and its provisions. That means what are the provisions of IPR? That what does it mean? How do you get benefit from that? What are the rules and regulations that you have to follow? So the agenda is this. I will be covering the meaning and forms of intellectual property. See, intellectual property or IPR is a kind of a property. So it has different forms. For example, when we talk about movable property, we have our vehicles are a movable property. Cash is also a movable property. Gold is also a movable property. Similarly, when we talk about non-movable property, a piece of land is a property. Okay, a piece of a building is a property. Similarly, IPR is a property and it has different forms. And that I'll be covering. And after that, I will be covering the competing rationale for protection. Why do I need IPR? What does it protect? And why do I need it protection? So these three things I'll be answering. Then once that is done, then what is the mechanism that's existing in this world for protecting my intellectual properties? There are international conventions because intellectual property is across the globe. That means it is not limited to one country or one region. It has to be protected across the world. So many countries have come together, conducted conventions, and they have come to an agreement which will ensure that my properties, my intellectual properties in India are protected, say in Pakistan or Europe. And finally, if there is a dispute, how this is solved using World Court. So who is the audience? For this presentation, I presume that the audience consists of engineering faculty who are working in engineering colleges, engineering students, that is because either as a student of a degree he will be doing a project work or he will be doing some research at MTech level, and research scholars, the people who are pursuing PhD or that kind of a course. So the audience is meant for this. Okay. And the next question is why am I conducting this webinar? The reason is simple. As an engineering fraternity, we will be involving in many activities that actually has a potential to generate an intellectual property. That is what I am going to cover now. The academic reality is that faculty, staff, and students of engineering colleges are engaged in R&D work of diverse nature. For example, as an engineering faculty, I will be involved in a research funded by a government, or one of my students might be doing a project which can end up in a kind of an IP activity, or there may be a departmental lab which has taken up an activity which has a potential to produce something. So the first and foremost reality is that as a faculty, as a student, as a staff, we are involved in an R&D activity. So this could be a project work or PhD. And many of these activities lead to evolution of intellectual property. For example, suppose I'm asking my student to develop a project or an algorithm which may turn out to be something which is commercially useful. Okay, so many of these activities end up in the creation of intellectual property. They could take a form of a patent or a know-how. Know-how means how to do a particular process. For example, if you're a chemical engineer, then doing a particular generating a particular solution is actually know-how. And it could be a copyright. For example, as a researcher, you may publish a paper in a journal, or you come out with a paper for the distribution. All these are under copyright. It could be a design. So if you are in a circuit branch and if you are designing a new chip, or if you are in a mechanical department, if you are designing a new vehicle, then that also comes under IPR. And there are many things like instruments and devices. For example, in an IoT, you may design a new device which is not existing earlier, which can become a cause for intellectual property. So the second point to be noted is, as a part of our activities, we may be generating certain content which could end up as an intellectual property. But why should we be concerned about this? The reason is this: these can be commercially exploited. For example, you are a student end up with an algorithm which can do some kind of an IoT search very efficiently. Then that can be actually given to a company which will implement it as a business proposal and run as a business and can generate some revenue. Okay, and such a commercial exploitation can also have a considerable socio-economic benefit to the country. So, for example, suppose you start an automotive industry and you have developed a new kind of a vehicle or one cost-effective vehicle, and suppose somebody starts manufacturing it, it will create a kind of an economic hub which will generate jobs, it will generate amenities, and also on, so on, so forth. So that's the second reason why you should be interested in IPR. And thirdly, the institute, normally any college, like whether it's IIT or engineering college, will encourage such activities of capturing those intellectual property instances and convert them into kind of intellectual properties. This would yield financial returns. For example, if a government is investing a lot of money in R&D, then if it generates some IP that can be sold or it can be commercialized, that in turn will give money back to the institution, also to the scholar and to the institution. So these are the three reasons. The summary is, see, as an engineering fraternity will be involved in activities like research and project work. This may generate some kind of opportunity for an IP creation, and this IP created must be protected so that it can be commercially exploited. So to recover the money that we have invested in R&D, or also to generate some socio-economic benefits. So now that I have told you, now I have to mention you what is IP. See, intellectual property is a new category of property. Means any property is actually important because two reasons. Because property gives you security, because if you have a piece of land, and it also gives you sometimes a wealth creation potential. For example, if you have acres of land, probably you can grow some wheat or other crop and generate money. So property has two purposes. One is it will give you security or protection, and it also gives you what is known as wealth creating potential. And this intellectual property is a handiwork of creative mind. When a mind becomes creative, and if it produces something, that can be an intellectual property. For example, if you are an author like Chetan Bhagat, you write a novel, that is actually an intellectual property because it can be copyrighted. Similarly, if you are a scientist who produces a new kind of an enzyme, then you are also a creative person because you produce a new enzyme. Similarly, if you are a mechanical engineering student, then if you invent a new kind of a device, then also it becomes IP. So what it essentially means is, when a creative mind is working, it will create something which is valuable. The moment it becomes such a valuable thing, it becomes an intellectual property. So it takes a form of an inventive solution. So why this is important? Because all this IP, they take an inventive solution. That means there is an existing problem, and this idea will actually solve it. For example, before Google came into existence, searching on the on the internet was a big problem because there was no straight way of actually finding the relevant information. When Google came into existence, they come out with an algorithm which says which information is important, how it is ordered. So any IP will give you an inventive solution. That means that was invented. Or a means to harness an opportunity. For example, today we talk a lot about solar energy, but we do not have an efficient method of actually harnessing that. But suppose some scientist or engineer comes out with a device which converts 100% conversion of solar energy into mechanical or electrical energy, that is also an IP. Or overcome a problem. For example, suppose you have a problem of pollution or some other kind of a thing like disease and all. So an invention will actually create a solution for that. So essentially summarizing is this: intellectual property is created by a creative mind. When it is created, either it will solve an existing problem, or it will allow you to harness an existing resource, or it could be a solution to an existing problem. So then what is IPR? So whenever somebody invents something of an intellectual property, that has to be registered in the regulatory authorities. The moment it is registered, it becomes an intellectual property. So intellectual property are legally awarded ownership right to inventor. That means somebody comes with an IP, an algorithm, or a method, or a device. The government will give authority, their ownership to him, and that is called IPR. That means intellectual property right. What is this right? Right to own that property and use it. They provide them exclusive rights. That means, like, see, if you have a piece of land, then you can always build a compound wall and say this is mine and nobody is allowed to enter that. Similarly, when you generate an IP and when you get an intellectual property right for that from the government, then it becomes your exclusive property. See, it is similar to a piece of land or a vehicle. For example, the moment you buy a new vehicle, you have to go to RTO and register it. The moment you register, it's your own vehicle because the records show you that. Like many other properties, IPR also takes different forms. For example, it can be a copyright. Suppose you are an author like Chetan Bhagat or a musical composer, then whatever the song that you create or whatever the novel that you write can be copyrighted because it's an intellectual property. It could be a patent. If you are working in an engineering domain, then you create a patent. Similarly, trademarks. See, business is a very competitive thing. So any business would like to distinguish itself from the others. So in order to establish that, they would have a trademarks. Then design, if you're a microprocessor company like Intel or AMD, or if you're a pharmaceutical company, then you want to design new drugs, you want to design new algorithms. That once designed actually becomes an intellectual property. Integrated circuits, geographical indicators. For example, now they have added the geographical indicators as a part of IPR. For example, now there are certain things which are known throughout the world because of the geographical location, like Assam tea or Tirupati Ladu, something like that. And trade secrets. Trade secrets are those which are kept as a secret within a company. For example, today Coca-Cola company has a trade secret. How to produce that cocoa drink that we have, Coca-Cola. So that is a trade secret. So the summary is this: intellectual property, when created, can be converted into actual property rights, and these are the 8 forms in which actually it can operate. So this is a picture which shows that. So the question comes like, why IP is so important? Intellectual properties are today's economic engines. The reason why we are actually bothered about intellectual property, because they have an economic impact. So for example, when somebody invented in Stanford University an algorithm to search web, that became Google. And Google, you know, today is actually one of the fastest growing company or very rich company. It has created many jobs, it has created many industries for other people and all. Similarly, for example, when someone actually invents a drug that will solve many diseases and all, and it will also create a pharmaceutical industry. And these ideas are all idea based. That means they happen in the mind and get a concrete form, and they become a product or a service. Say for example, chemical formula used in a drug. So the moment you find out a chemical formula which can effectively overcome a particular disease, that becomes important, because that would solve many health problems. Similarly, algorithm used in a search engine. So the reason why IP is important, because it has an immediate economic implication. And the next question, if it is important, it must become a part of an education. For example, IP education is concerned about creating awareness. We as engineers, we as other practitioners like doctors and all, we must be aware about the existence of IP regime. It is like, say, basic health education, basic road education, about transportation education. Similarly, IP is an integral part. See, any citizen of India should be knowing little about Indian Constitution, right? Similarly, IP is a very essential thing. So IP education is all about creating that awareness and appreciation. So you must know that there are advantages of this IP, there are responsibilities of this, that you must be knowing. And its promises, what are the benefits of getting IP education, and what are its potential, how is it going to help an individual researcher or an inventor or an institution or a nation, that is must be noted. And associated responsibility, like see, when you are traveling on a road, you have to follow certain rules and regulations, because for both benefit of yourself and the others. So there are responsibilities also included in IP. Scope of IP education. See, IP is actually a big thing, because whenever you talk about intellectual property right, it has a technical aspect, commercial aspect, and a legal aspect. So what we have to know as a general common person is actually basic IP education, like what are the IP forms and how to get them. Whereas IP education for the practice, you can be a legal specialist who will be dealing with patent law and all. For that, you need a different kind of education. IP education in law, if you are a lawmaker like a parliamentarian or a government official, then you have to know IP in a very different level. So in general, IP is there for common man, for a practitioner, and a lawmaker. What does it actually consist of? It consists of educating about the nature of IP, what does IP is all about, its classification, that means what are the different forms, and the legal framework, what happens if you own it, what happens if you misuse somebody's property. Okay. Why should have IP education? Economy is driven by ideas today. That means you may end up with a good idea which will become a novel tomorrow, or you come out with an engineering idea which will become a product tomorrow. For that reason, to recognize that idea can create wonders for you, including wealth, you must be knowing about that. Secondly, there is a globalization today. Today's world has become very global and it is very narrow. So idea in India can actually become a great success elsewhere. So, but in once become successful, there are always competition who will try to copy it and do certain things. So in order to avoid, you must be knowing what are the schemes and ideas, what are the schemes and rules which will protect that idea. Thirdly, national heritage is also becoming part of IP. For example, you maybe know the story of like basmati rice being patented in America, or yogasanas all being patented in Europe and all. So in order to avoid this kind of a problems, you must be knowing about IP education. Ideas are not new, because ever since the man started living on this earth, ideas have played a critical part. But today ideas are playing very critical part, because today we are living in what is known as a knowledge economy. Knowledge is always expressed as an idea, and idea takes the shape of a different IP format, and those who have a potential to generate wealth, hence they become predominantly famous today. Okay. So now interaction time. Any questions on this? What I have covered so far is what is IP, who must be knowing it, what are its benefits, what are its provisions, and what are different forms. So is there any question?
What are exclusive rights?
So what exclusive rights is like this. See, if you have a piece of land, then if you build a compound wall that only you can enter, that means you entering to that building or entering that piece of land exclusively yours. It is not given to anybody else. Exclusive always means only special advice, means special property, rights given to you. Your exclusive owner means only you are the owner. Nobody else can even touch it or think of using it.
Yes, sir. Only one question.
Okay, I'll proceed. So now that I have told you the basics of IPR, then I will move on. So why IPR should be considered in a social setup? So there's a competing reason for this. Business environments is very competitive and sometimes even very hostile. So when competition becomes intense between Microsoft and Google or IBM and other companies, now what happens is the only way to protect your market is through your products. And if the products are patented or they are protected through IPR, then you have a better chance of actually surviving in the business. And IP have a key role to play in economic development. And more of the IP a particular country develops or a particular company develops, then actually it has a great advantage for you. Probably you remember in the last 2 years, actually Google bought the Motorola company and their mobile division. The reason was this: there were a lot many IP, patents which are owned by Motorola, which was actually preventing the further growth of Android system. So what Google thought that instead of actually fighting a legal battle for every patent which is violated by them, in case of Motorola, why don't we buy that one and actually use them? So that's exactly what that. So that means IP has also economic reason. So the reason in this business is competition. One of the best way to lead competition is to own as many IP as possible. So value of IP, okay. It opens up new frontiers for every human field. For example, whenever somebody makes a patent like Google search engine, the other people will try to develop a better application of search engine. So that will create a kind of a competition, and every competition will bring best from the competition. It will also help inventions. That means people are ready to share their invention because they know that it is protected by law, so that they can freely share that. Okay. And it will also help transfer of technology. For example, suppose there is an invention, say in Europe or in America, and those inventors can actually share their invention with India because it is legally guaranteed that their technology is protected, and they will get revenue for whatever the use they do in the third country. So socially, it is actually IP is also very important. But what does it give for the inventor? See, for example, Google algorithm was invented by those two students. Okay, and what do they get? Guarantee of inventors is the rights to commercial exploitation. That means if your invention has some commercial meaning, the IPR, intellectual property regime, will give that right to the user. Limited duration. Although it gives that one, it is only limited for 20 years. The reason is this: after 20 years, that property becomes a public property. Anybody can actually use it. So the advantage is for the first 20 years, the inventor can enjoy whatever the benefits, and after 20 years, the whole society will actually enjoy it. And if you have been following pharmaceutical industry in India, so many of the medicine or drugs that we get today in India are based on the patents which have expired in the United States or Europe. So the advantage is that since those patents are expired, anybody in the world can use. Whatever the limited extent to that it can help, but it certainly helps some people who need a medical care. And it also inspires people to make improvements. For example, you come out with one particular design and the competition will become more because they will make improvement on it. So from an inventor perspective also, IP is important because it encourages them to share their knowledge with the society. And secondly, suppose you have an intellectual property right, no matter how small or how big are in the competition, the law will actually protect you. See, sometime back there was a fight between two companies called Microsoft and I4I. This was a Canadian-based company. So Microsoft is fined because a huge amount of infringing that's done by a patent. See, this I4I company had a patent which was able to convert a document into XML format. That means if you have a Word document or any text document, they had a patented algorithm which will convert your HTML, your text document into XML document. So when Microsoft started converting their document MS Word into web compatible, they also used that same idea. But since it was patented by I4I, they had to pay a lot of penalty because courts decided that. So the point is that if you have a patent, even if the opponent is very big company like Microsoft, still you can get your share or you can get it protected your idea. So that's the second reason. What are the benefits of IP? It's an incentive for investor. That means if you have come out with a good idea, then you make money or you make a name and fame. Okay. And it protection is a challenge for competitors. The moment you come out with a new idea and a new patent, the competition will also start discovering different methods. Okay. So for example, Google come out with a different search engine, and other companies like Bing and all, Microsoft, they're also trying to find out another one. So that's another advantage. So now, how do you know that actually your ideas are protected across the globe? Because see, today we live in a very connected world because of internet and all. So how do you actually ensure that your ideas are protected by law? Because you may invent something in India and that needs to be used in China. How do you ensure that? Okay. For that, people and governments have done many things. For example, they come together and create what is known as a convention. We have also a world code. I will go a little speed on this. So there are international conventions which come to, which bring together governments and they decide what to be done with this. Say, for example, they have come out with ideas so that each country will actually protect ideas and the patents of each other country. So there are 4 conventions that have happened. For example, there was a Paris Convention, which actually is a collaboration or an agreement about patents and designs. Similarly, there was a Rome Convention, which was regarding performance and phonograms. That means you write and all. Similarly, the most recent one, Geneva Convention, which is about plant variety. That means today, biological products also like plant hybrid elements and all, they also become a part of an IP. Similarly, because of the participation in the convention, each nation has a responsibility to protect the IP which is established elsewhere in the world. Similarly, it has to also should not discriminate among the people, because it should not say because he is our national, his ideas will have a precedence over the other. Once the IP is registered anywhere in the world, they must be given equal this one. And if there is any dispute and all, the world court will decide this one. So now interaction time. So what I've explained so far is actually why IP must be taken care, because it is a social and social implications. It also has economic implication. It encourages an inventor to do certain things, and if there are disputes, there are agreements across the world, across different countries, including a world court. Any questions on this so far?
Yes, sir. Can I have the patent on ideas?
No. See, patents on ideas is not allowed, because ideas implemented in a way must be patented. See, and when we talk about patent as a procedure, different countries have different things. For example, in India, patent can be given for an idea which is implemented, whereas in America, even algorithm can be patented. Say, for example, Google has patented the algorithm in the United States, but in India, if you want to patent an algorithm, it is not allowed. They say you have to have an implementation, and that implementation using that algorithm can be patented. So countries differ in what can be patented, what cannot be patented in their countries. In general, ideas are not patentable. Only their implementations are patentable.
How can it be shared if multiple patent members are there?
No. Actually, multiple patent members are there. Actually, whenever you go for a patenting process, when you apply for a patent, there is a distinction between an inventor and the owner. So if there are multiple inventors, then you will mention that actually these are the different inventors, and ownership can be shared by them. It's like sharing a common property or having a joint bank account, where actually there are 2 or more people who will be operating that account, and all of them are equally ownership. Okay, something similar can be worked on that. So there is a shared ownership also, and there is a single ownership also.
If you gave one improved solution to the existing solution, is that a IP?
Yeah, see, if it is, what is the actually inventive step? That means, see, the one step that you have given is actually dramatically changes the whole process, then that can be patented. For example, suppose you have a diesel engine today or a petrol engine which is giving a mileage of say 100 kilometers, and suppose you give some method of doing something in that engine which gives the mileage of 200 kilometers, and that idea that you have given which has made that engine from 100 to 200 can be patented. Yes.
Is it necessary to patent an invention in every country?
Yes, depending on the implication. For example, see, it's like if you patent something in America, then Indian government doesn't have a responsibility of protecting it in India. So it needs to be patented in India because the government has to know that there exists a patent which is operating in that India. So this process of registration to say that I have a patent itself is actually a process which is needed. So if you want to operate in America, your patent must be patented there. If you want to work in Europe, then it has to be patented there.
Can presenting your idea or product in international TPP act as an IPR?
Pardon, sir?
Can presenting your idea or product in international TPP act as an IPR?
No. Actually, see, just sharing an idea, presenting in a presentation and all, they are called disclosures. Okay. So when you are disclosing, you have not patented it. So normally, patenting is actually a different procedure where you go to respective authorities and patent. So if you are an international conference, you are told an idea which can be converted into patent, still then you will be known as somebody who disclosed it. But somebody who goes and registers will become the owner of that. So patenting or registration for a patent is a separate activity other than actually disclosing it.
What are the differences between a patent agent and patent attorney?
No. See, patent agent and attorney are practically same. Since patenting is, I told you, is a techno-legal commercial, there is a technical part into that only engineers or doctors will know. There is a legal part only a lawyer will know. And there is a commercial part only a business will know. So somebody who is supporting your patenting process, who has a legal knowledge, is called legal attorney. So attorney would mean somebody who is good in legal aspects. So patenting agent and patenting attorney are same. But many a times some businesses will actually help you to patent your ideas. So those business entities are called patent agents. It could be an individual or a corporation. But the actual person who is actually drafting is actually a lawyer. Lawyer, at least he has the legal knowledge. So he is called attorney.
One patent can run as in different countries by multiples.
Yes. So it can be patent. For example, see, I told you Google search engine is based on an algorithm which is patent there, which cannot be patented in India. So, but that can operate here. Secondly, a patent to different degrees in different forms can be implemented in different countries. Yes.
How do we file a patent?
Okay, that I will probably take another session next week or so. But it's very simple. The moment you come out with an idea, if you think that it is worth going, and you have to go to a attorney, or if you are, say, if you are working in a college like mine, we have an intellectual property cell. You go to a concerned faculty and say that I have a patentable idea, and there are different stages like disclosure of your invention, and then making a draft copy of that one, and then making a literature survey and all. Probably that step I will take in another session.
If I have an idea of an Android app and I have implemented it, then can I have the patent on that application?
Yes. If you are not already published, or if you can prove that it is your idea you have implemented before anybody else has done, then actually application itself can be patented, provided what part of the application that you are patenting, whether it is a functional part, or it's the appearance part, or it is the code part, or it's the algorithm part. Depending on what is allowed in a particular region or a country of this, it can be patented. Yes.
Which is a good open source tool for patent search?
Patent search, actually, normally Google itself has a patent search. So if you go to Google and say patent search, then they will take you to another URL. So which has access to most of the published patents in that. Yeah.
Yes.
Google patent search is the best one. Yes, sir.
Okay, you can continue, sir.
Yes, sir. So now I will move on to the next section. The intellectual property, I told you, take different forms. So like I told you, a movable property could be a car or your vehicle. Vehicle or your watch or your mobile. All these are properties. Similarly, property like a landed property or a building or a plant or a tree, everything can be property which is immovable. Similarly, IPR can different forms, and in this section I'll be covering them. So the forms of intellectual property, they could be copyrights, they could be patents, they could be trademarks, designs. I will cover each one of them. Okay. First and foremost is actually called copyright. So this is one of the oldest IPR, which is there for last about 600 to 700 years. Because when people started printing books using a printing press, which was invented in 14th century, we had this new set of people called authors, and to protect their whatever the writing, they actually come up with this particular copyright. So I'll be covering the meaning of copyright, what does it contain, ownership and other things. Okay. Copyright, I'll tell you what is the meaning. It's a form of an IPR. So copyright is an intellectual property. It protects the rights of the authors. So authors are those people who write something. For example, a novelist like Chetan Bhagat is an author, or somebody who will compose the music is an author, or somebody who will write an algorithm is an author. So for that reason, books are copyrighted, films are copyrighted, songs are copyrighted, and algorithms are copyrighted. So copyright is a kind of an IPR which protects the author's creative work. So copyright, its definition is this: copyright creates in the author an exclusive right. Somebody asked me what is exclusive right. See, suppose you write a novel, then you have the exclusive right of doing many things on that. That means you can produce it. For example, you can write a novel. You can actually change that novel and make a second version of that. You can publish it on your own and perform. And all these are exclusive. That means no one else can do these things on your work. Okay. And in all ways known and possible. That means you can write a novel and publish it as a book. You can write a novel, make an audio recording of that and publish. You can make a video and sell it. So all known and possible ways you can have the ownership. Copyright is given without any kind of registration. That means the moment you write something, for example, the moment you publish your blog, you actually are the copyright owner. There is no additional registration needed. However, suppose you want to establish your copyright, your authorship of that, it is always better that you register it. See, registration recommended, it gives certified. That means the moment you publish a novel, suppose you submit it to the authorities which actually register this work against your name, it's always good. Because many times if you become a very famous novelist, or if your programs become very famous and it has to reach a wider audience, then this document will help you to establish that you are the owner of that. And it also helps you in the succession of issues. But that means if there is an author who is very famous and if you have 10 books published, and what would happen to those copyrights once he is no more? So in that case, to establish that he was the author, copyright is needed. So as per the copyright law, the following can be copyrighted. Original literacy, that means you can write a story, you can write a poem, you can write a novel, and you can do that. And dramatic, that means dramas, plays, they can be done. Musical and artistic work, lighting, painting and cinematography, that produce a movie, documentary, that can be patented. Sound recordings, that like music or instrumental. Okay. So what are the rights given to user? I mean the right holder. Free produce work in any form. That I told you, you can write a novel, make it a film. For both you will have a copyright. Publish the work, you can publish it, perform in public places. Suppose you write a drama or a play, then you have the right to play that drama. Translate that work. Suppose your novel is very successful, say in English, then it can be translated to Hindi. Even the Hindi version, you will have your copyright. And broadcast and telecast, that you're not making a serial and all. Adapt the work. That means, say for example, you can actually make your your drama into a film, or your novel into a film. So these are the different rights which are given to you. Now we'll talk about the ownership. Author is the first owner of the work. That means somebody writes a novel, he is the author and he is the first owner. However, author can assign the ownership to others. For example, publisher and performer. So that means you write a novel, then that can be given to a publisher like Higginbotham's or McGraw-Hill or Eastern Valley, obviously, and all the you can publish it, you can give that. Ownership remains with you, but the right to publish goes to somebody. Or it could be, suppose you have written a drama, then actually that can be given for playing to somebody else. For example, if you know Chetan Bhagat's Two States novel, no, it was a novel as a published, but then it was converted into a film also. So that was a performance. Author may assign one or more of his copyrights to one or more forms. For example, you may say like my novel publication is go to this publisher, but if you want to convert it into film, it will go to another company. This can also be done. Licensing is also possible. For example, if you are a worldwide famous author, then actually you can say I want to publish this book in Chinese language in China and Mongolia. So that is called licensing. Okay. Similarly, I want to translate this particular novel and publish only in South India. Then that is also licensing. Maybe if you are a faculty or a student, you know there are many books published today which have a label on that. This book is it can be sold only in Indian subcontinent like Pakistan, India, Sri Lanka, and Bangla. So this is called licensing. This is normally an American or European book which is published there, but it is licensed to be sold only in this region. Copyright registration. That means if you want to register your work, you have to go to an office which is there in Calcutta, and you have to register. That procedure you can learn anytime. Okay. Copyrights. I told you these are the things for which copyrights are there. And in case somebody actually violates, that means you know that you have written a novel and somebody else is publishing, then actually you can put them into legal process and find that one. So infringement is a technical term which says that somebody is actually misusing the property which belongs to you. That means you have written a novel, somebody has published. That's an infringement. You have published a drama and somebody else is playing without paying you the royalty, then that's an infringement. Or if you have published a film or a photograph which somebody is using without giving you a credit, that's called infringement. However, copyright has one special class. For example, as a teacher, you want to use certain paragraphs of a particular book for your teaching purpose. But according to the rules, the published author has complete right copyright on his content. For example, if you want to use a quotation from Bible, or if you want to use a quotation from a novel. So in order to support that kind of a teaching activity and all, copyright can be allowed to what is known as fair use. Fair use what? You are allowed to quote certain amount of content from different books or different works in order to for a discussion or for a teaching or publication and review. See, look at this. Fair uses small portion of the original material can be used. For example, if you are reviewing a novel by Sidney Sheldon, then actually you can say part of that novel or piece of that novel can be quoted in your article. Similarly, if you are using film, when you are reviewing a film, a Bollywood film, then part of the quotation or part of the song can be quoted in your article. This is called fair use. And now here I'll show you, for example, if you are using a motion media like film and all, up to 10 to 13% it can be used. Okay. So in case you find somebody who is misusing your property, there are legal and other ways to protect that one. Offenses, that means if you are found the guilty person, then there is law which will take care of putting them some kind of a penalty or putting them behind bars and all. So any questions on copyright?
No questions, sir.
Any question on copyright?
No questions, sir.
Okay, I'll move on to next one called patent. Okay, patent. So once I've covered copyrights, now I'll move on to patents. Patents are more relevant to engineering audience because normally we don't have copyrights issues. We have always patent issues. So what is the concept of patent? Patent is a state grant in the name of the inventor. The way you write a book and get copyright, similarly you make an invention and get a right for that, and that's called patent. So look at this, patent is a state grant. State means it is given by the government. And whom does it give? In the name of the inventor. That means if Einstein comes with a particular idea or Edison comes with an idea, the respective government will give him a right, and that's called patent. It is a time period. Unlike the copyright, see, the validity of patent is only for 20 years. That means if you invent something in 2015, by 2035 it becomes a public property. Patent is a privilege for making, manufacturing, selling, or using the invention and right to authorize other to do. That means when you make an invention, you are allowed to make that. That means you can produce, you can use that and manufacture it. For example, if you come out with a specific design of a chair, then you can manufacture it, or you can sell it, or you can use that invention and give other rights to other people to use it. So that is what is patent all about. What is the purpose and policy? When you give patent, the inventor is always encouraged to participate and share his knowledge or his design. So encourage research and promote inventive genius. So suppose somebody has a great idea and he knows that if he shares this idea after patenting, he will get rewards for it. So that will help him to do that. Maintain flow of invention. That means somebody publishes the invention and somebody else is got encouraged to do that one. So that is the reason why patenting is allowed. So how to get a patent? So for example, somebody asked me like how to get a patent. This is where it is there. So application for the patents. The following persons can make application for the patent. So if you are an inventor, you can make that. Person claiming to be the true and first inventor of the invention. So if you come out with an idea which can be patentable, then you become the first and the true inventor. Okay. Say suppose you are doing a research in, say, an engineering college. As a part of the research, if you find something which is patentable, then you are the inventor. The assignee of the inventor. It is also possible that you authorize this authority to your college. So on behalf of the college will actually go. In that case, it's called assignee. It's like, say, in a property matter, there's something called power of attorney. If you have a piece of land you have to sell, and if you are not, there to sell it at all, then you can authorize legally to somebody. Similarly, you can give assignment to others. So what are the patentable invention? Patent is issued by only such those inventions which are new and novel and have a commercial value. So there are countries in the world which actually give patents for the very fancy ideas, but by and large countries will give patent only if they have a commercial idea. Invention must not be known earlier. So the one thing and one essential thing about patent is the patent should be very new invention. It is not known earlier. Okay, and it must have a usefulness. You don't give it for this one. So inventions could be art or a process or a method. For example, you can develop a new kind of a procedure or a process. For example, if you're a chemical engineer, you come out with a chemical process which will give you a higher yield rate. Method or manner of manufacturing. So you find out a method so that actually you can reduce the cost of manufacturing. That can also be patented. It could be a machine like steam engine and all, or an appliance like a watch. Okay, other article. Substances produced by the manufacturer. You can come out with some kind of a chemical which, say, improves the fertility in a particular land and all. So all this can be patented. So publication of an invention is the announcement. So once you know that your idea is patentable, then you approach the authorities. So they will make some kind of a procedural things and they will announce. That's called publication. It's like publishing a book. If the invention is known and in use, it amounts to prior knowledge. That means they will not allow you to publish that. Okay. So procedure for obtaining a patent. Somebody asked me how to get a patent. Here is a procedure. Patent is obtained through an application. That means unlike in copyright, you got to apply for that. Okay. Application must be thorough and complete. That means it's like applying for a visa or any other government document. The application should be thorough and complete. You cannot miss certain columns. You cannot miss certain document, certain information and all. There are 4 stages in patent process. First stage, office objection. That means the moment you apply, the office may say that patent office, no, this is not a very new novel. There are already existing patents which actually are similar to this. Or if it is very novel, then they will grant you a patent. That means they will give you that one. Or post, and then once it is done, it is possible that somebody in the market, somebody in the society may object to that. That's called post-grant hearing. The patent office will invite people to have any objections or towards that. And once they are not there, then the final order is given. Anybody who thinks that he already has a patent for which a new patent has been issued, he can go to office and oppose that one. That's called opposition. Okay. So once the controller makes the order of granting patent, the applicant has to make an application for the issue of patent and sealing it. So once all this procedure is over, then you can go with your patenting process. So any questions at this point of time? So what I have covered so far is actually patent is a second important thing of an IPR. Unlike the copyright, it gives you ability to use your invention for a limited period of time, and it also gives you authority to use that in manufacturing or in giving it to somebody. So any question at this time?
Yes, sir. Why patenting process takes so long in India, like 5 to 6 years? Is it the same case in USA? What is your suggestion to make patenting faster?
Yeah, see, when patenting process normally takes a long time, no matter which country of you are living. The simple reason that actually patenting insists that idea should be novel and new. So in order to see that doesn't exist, it needs a lot of searching. For example, if you apply for a patent in India, somebody has to search through all existing patents in India before making a conclusion that is novel. But this must be extended to throughout the world. For example, everybody also has to go through this kind of a thing in Europe, America, Japan, and all those countries. Okay, so that's the reason it takes a long time. But now there are some treaties called PTC and all. Okay, patent transfer controlling regime and all, where actually different countries are cooperating with that. But the good point about this is actually all this patenting officers give what is known as the provisional patenting, so you can start using that until somebody objects to that. Okay, so it is true that it takes a lot of time because it's the nature of the work, because you have to ensure that that kind of a thing doesn't exist anywhere in the world, and every year millions of applications are coming. It normally takes time, a lot of time. Yes.
What are the fees to be paid for getting a patent?
See, actually, if you look at the government fees and all, the application fees is very simple, very less actually. It then runs into a few thousand, less than 10,000 or so. But actually, I told you, patenting process is actually a very techno-legal issue, meaning that as a scientist, as an engineer, you may know the technical part of your research, but you may not be knowing the legal implications and commercial results of that. So for that needs, you need to consult an expert who will see your patent, your idea from a different perspective. So this he does with a fees against it. So normally a patenting will take anything between 40 to 60,000 in India. It's a normal case, and depending on the intensity of the patent and the coverage it has to make. Okay, so that's a normal price.
Previous question over, they are saying, do they search for 5 to 6 years?
No. They don't do search actually, sir. Searching will be done in say 1 or 2 years. Normally, the time they take is 18 months. But after that, there is a procedure I told you. They would actually give you like a temporary or a tentative patent. Then that will be put into public domain for any confirmation or any opposition and all. So this procedure will take a long time. But the user, the inventor can start using his patent or implementation the moment it is granted to him. Yeah, just after 18 months.
Can we file patent when research is still going on? That is, partial work is completed.
No. Yeah. See, if your research has produced some results in halfway through or about 60% of the research, that can be done. See, there is no relation between your research and patent. What patent says is whether you are doing the research or not, or you are getting an idea somewhere elsewhere. If it is novel and if it is useful, then you can patent at any stage of your research. And improvement can also be done. For example, when Google came into existence with a search algorithm, it was very simple. It was searching only things. Now today they have improved such a lot that they have millions of parameters which Google search engine uses to give a get result. So that means it's also a continuous process. But the patent they made in 1998 was very simple, but it can always be improved. For that you get a additional feature patent. New patents you will get for new additional features. Improvement is always allowed. Yes.
What is the provisional registration of a patent? How long does it remain valid? How much time is considered for converting provisional patent into final patent?
No, actually I told you, the moment if you think that your idea is good enough, and if a legal and a commercial expert says that, you can make a provisional thing and actually start working on your thing. And normally within 18 months they would say you something, okay, whether it's patentable or not. But if you think that you are very confident and all, then you can start using it. So patents normally will be given from 18 months. Then an inventor can use it for next, up to 20 years. Okay, so that is what it is.
What is the indication to know whether the author is the first author of the work?
In a book and all, so that is normally whenever you publish a book and all, there is an author. You are talking about patent, right, sir? So patent actually, I told you, suppose you are an independent researcher and if you are publishing, then you are the inventor, you are the owner. But suppose you are working for a company or institution, there are some procedures. For example, if you are working company like a Microsoft and all, what it says is the inventorship it will give to the employee, but ownership is retained by the company. Similarly, if you are working for any R&D lab in Indian government and all, the ownership stays with the organization and the inventorship goes to you. Okay, so there is a different distinction between inventor and the owner, but all those things are published when a patent is published. You will see every detail like inventor name, publisher name, owner name, all those things are there in any patent document.
Those are the questions, sir.
Okay, I'll move on. Okay.
Yes, sir.
So now that these are the two important things which in engineering fraternity you should know, but there are other things. Okay. So, but if you are really into the patenting procedure and all, there are many other things that you should also be knowing. Rights and obligation. As a patent owner, you have the obligation. This is a little higher thing that probably we will discuss later. Infringement and remedies. That is what happens, what you have to do when somebody infringes your patent, or what happens when you are infringing somebody's this one. And in case you encounter an infringement, what are the remedies which are legal and otherwise? And offenses and penalties. That means you can actually infringe to certain extent. For example, you can enter somebody's house, but that is normally pardonable, right? It's forgivable. But suppose you enter somebody's house and do some kind of a mischief and all, that is punishable. Similarly, in infringement, there are provisions. So some things are forgiven, some things are actually penalized. All you must be knowing. Let me go a little fast. Okay, so in addition to that, we have these trademarks. Trademarks are very much an IPR because they are needed in a business. Okay, why trademarks? So trademark is actually for an individual or a company. For example, Tata have a trademark like this word Tata. Similarly, Microsoft has BBC and okay. So name, reputation, expectations are all part of trademark. The moment you see a Tata logo, the moment you see a BBC logo, you know that this is to be expected from that. So similarly, the moment you see Coca-Cola logo, that is there. So trademark is used for companies to establish their identity in the minds of the consumers. What do they do? Actually, trademarks guarantees consistency in quality and goods. For example, you may ask a particular blade or a particular scissor or a particular biscuit from a particular company. The reason is you know that the product from that company is actually good enough. From a user perspective, that simplifies. For example, market is crowded with so many products. Then when you want to choose a product, then one of the easiest way to is go by company name, and one of the easy way to identify companies actually through a trademark. Trademark is a physical form, is a symbol. I told you Tata or Microsoft or something like that. Okay, it can be affixed on a product. For example, today you see many publishers coming with a hologram on their books to show that, see, kindly avoid duplicate copies. You use only this. That hologram is also a trademark. Look at this. There are, for example, Sony, Intel Inside. These are all trademarks. Registering a trademark, if you're a businessman, like copyright, patent, you have to go and make a registration. What cannot be registered? Non-distinct words and symbols. For example, you cannot go with an English word and say patent. A word particularly written in a particular format can be patented. For example, when you say Microsoft, it is a particular font, particular color, particular size. That can be patented. But a simple typewritten word like Microsoft cannot be patented. Application for a trademark. This is if you really have need, you can go for this. Procedure for registration. This is also simple. You can always see the presentation. And next one is actually industrial design. This is the fourth category of this one, where actually you design. I mean, you have a design. For example, you designed a processor, or you designed a chip, or you designed an engineer, or you designed a chair. Then for that, if you want to pay, if you want to take an IPR, this is what happens. So, for example, handicrafts like see khadi and all, watches, jewelry, fashion, luxury items can be patented. Look at this. See here, somebody has designed a screen. It's an industrial design. There's a particular chair. You can be taken industrial design. Maybe you know that we have this plastic chairs coming from a company called Neel Kamal. So in many of the airports, railway stations, and all you find. So that chair is actually patented because that chair has certain features which allows you to, for example, if there are 10 chairs, you can put one chair above the other and make a rack out of it, which was not earlier possible with other chairs. Okay. Industrial design and procedure for registration. This is very simple. You have to go to a respective office and get it done. Like a patent or a copyright is also granted to you. Industrial, in somebody infringes, then you know trademark issues are there, okay, all the time. So now the interaction time. Any questions on these trademarks and industrial design?
No questions yet, sir.
Okay. So I'll come to on conclusion. Okay. So these are a different kind of things. Copyright for any published work, patent for any invention, trademark for any business identity, trade secrets for any formula that you have in a business. So the conclusion is IPR is an important tool for protecting our academic and research results. So if you are in an academic research, you are doing a research, and if you come out with an idea or a procedure, IPR gives you a protection, a legal protection for that. So for that, it is very important. The basic knowledge of and practice of IPR is a provision must for all concerned, whether you are a student or a researcher or the faculty or a principal or a dean. The basic idea is very much required. Like see, knowing the essential features of Indian Constitution or knowing all the rules of road transportation and all. So that is very minimal. IPR is a techno-legal and commercial in nature. That means patenting looks simple, but it has lot many legal and commercial reasons. For that, you need an expert advice all the time. Okay. So this is my contact information. Any questions, if you are not asked in the session, can be sent to here.
So one question is there. What is trade dress?
Trade?
Dress.
I don't know. Trade secret, is it?
It
There's
says
trademark and trade secret.
it says trade DRESS.
No, sir. No idea, sir. I think that doesn't come part of this.
Okay.
Traders is there. I have not heard this term.
Okay.
Okay, thank you very much for giving this session. And I think I have tried to give some glimpses of what is IPR all about. In future, if possible, we will conduct one session on how to apply for a patent and all, and also how to develop and evolve